So this is workshop number 5 for intellectual property law, and it's dealing with consumer rights and the doctrine of first sale, or the first sale doctrine, whichever way around you want to put it. There isn't a presenter for tonight, which kind of shortens the proceedings somewhat, but I'll spend some time talking about what I think are the important aspects of the workshop and the week, and then give you a chance to ask questions if you have any, and we'll see how we go from there. Okay. First thing in terms of announcements is I have the rubrics, the assessment rubrics uploaded to Moodle today. Sorry it took so long to do all that, but I felt you probably needed your course materials there first before the rubrics, and it's deeply, deeply shameful that it's taken to week 5 for me to put them up there, but hopefully they make sense now. And I'm not sure if you've been introduced to rubrics thoroughly before, but the idea is these are criterion-based rubrics. So it's not a case of that they set benchmarks for each level of achievement. So it's not a case of, you may have seen old-fashioned rubrics where you get 5 marks out of 30 for this and 6 marks for this, and they're added up individually. With criterion-based ones, there are a set of benchmarks. You have to hit each of them to go up to another level. So hopefully they will make some sense, they'll help you understand what it is I'm looking for, and particularly in the written assessment pieces. Okay, and I had some other announcements that have totally slipped my mind, but we'll keep going from there. Oh, the other announcements, of course, was that it's the break week next week, and we won't have classes for a whole week, and it's customary, I guess, for all lecturers to say have a great holiday, but I know you guys are all working, so that's not really going to be an issue for you, is it? At least you won't have classes on Tuesday night. Alrighty. Now, doctrine of first sale. What do we need to talk about there? I've just written this, so I should be able to remember it all. This week is probably the most conventionally lawish of the IP law weeks, which maybe that's why no one's well, we've got a very small attendance tonight, because maybe that's maybe people find it boring. In the past, some of the student feedback I've had for my courses is the few people have felt there's not enough sort of solid black letter law in them. So this is me addressing that balance, at least the way I address the balance, and looking at something which is really about the intersection of IP law and contract law, specifically licensing law. And it looks at the way in which licenses can and can't be used to regulate the rights of the IP rights holder and the consumer. And the design of the workshop, which of course, if we had presenters, would be around an arbitration, an argument around an arbitration clause. And the reason for that was we wouldn't have to worry too much about the legal procedural aspects. I fear often when we have moots involved in courses, people get more stressed out about the procedural matters than the substantive law, and I didn't want to be a whole session where people were just getting stressed out about the legal procedural parts of it. So I went for arbitration, where the law is relevant but not necessarily determinate, and the procedures are open. So that's why it was an arbitration. It was also a good opportunity to talk a little about around arbitration as a methodology, because it has a very interesting relationship with law. It's because it's an alternative dispute resolution format. It's not bound by law. It's not bound by legal procedure, but definitely having the confidence of the law behind you makes a big difference. And there's certainly an idea that if someone is really confident of their legal rights, they generally won't, and their ability to recover a remedy, they generally won't go to arbitration. So generally when arbitration occurs, it's when both sides are feeling it's in their interest to do so. And often it'll occur, as in the case in this scenario, where we're talking about an international matter where the actual access to courts becomes quite difficult. And if you have an arbitration clause, it's generally you can do it online. You have lots more options than trying to put a matter before a court. But anyway, that's a bit by the by. Now, in terms of the substantive material for this week, as I mentioned before, it's about contract, it's about licensing, and it's about the ability of the IP holder to place further requirements and restrictions on the usage of consumers. Now, generally speaking, the fundamental principle of contract law is once you sell something, it's gone. It's the property of the person who's bought it. And really where the first sale doctrine comes from is that fundamental principle of property law. And it can get a bit confusing, and I know the reading this week talked about it being a principle of IP law, which it's not really. It's actually more ingrained in contract law. But it's the basic idea that if you sell something to someone else, you can't leave one hand on it, so to speak. I can't sell you my car and then say, but I need it back every Tuesday. Because once you sell it, the title passes. But over the years, there's been various requirements that owners of property have tried to place upon property. It's not just intellectual property, it can be any kind of property that would limit those rights. And generally speaking, what the courts say is that once it's sold, property passes completely, you can do what you like with it. Now, obviously, there are some IP law places limitations on that of themselves. So, for instance, the copyrights of something doesn't pass with sale. So just because I sell you a book doesn't mean that you then have the right to print more copies of the book. So copyright law is itself a kind of a statutory limitation on the consumer's rights. And as copyright law is extended, of course, more and more consumers' rights have been extinguished. At the same time, you'll remember this from contract law, though consumer rights legislation has also boosted consumers' rights. So we're actually hitting a situation where we have increase in both these areas of rights and not necessarily any clear indication of which ones may end up being supreme. So all the Digital Millennium Copyright Act changes, and in Australia, of course, that's the Digital Agenda Copyright Act for who knows what reason. We just used a different title, but they put that created offences around breaking anti-circumvention technologies. And they again restricted your rights. It said not only were you not allowed to make copies of things, but you're not allowed to tamper with the copy protection under those laws, although those laws have been read down quite a bit. Okay, question from Grant, is that why? Yeah, that's exactly right. And what you're getting to here is the crux of the matter, which is the second-hand market, and that's what the doctrine of first sale was invented to protect, and that's what the original cases in the United States were about. Was about IP rights holders trying to stop the second-hand resale of books. And the same with DVD. So as Grant's asked, how I can resell, swap, etc. movie DVD, but I can't break the copy protection. You can't legally. And that's exactly it. Okay, so we can already see IP laws, particularly copyright laws, a restriction on consumers' rights. They restrict what you can do with a particular property. Moral rights are another interesting restriction, because they say that you can't. You have that the artist remains, the original creator retains the rights of attribution and the rights of integrity for work. So that's those rights are included in the Copyright Act, but they were rights signed under a convention, the Berne Convention, and they would have stopped several things. One is, for instance, me buying a painting that you've done and then telling everyone I did it. So even though I've bought the painting, I don't buy with it the attribution rights. The attribution rights remain with the original creator, unless we specifically enter into agreement where we negotiate. I buy the attribution rights and say, you know, you've painted it, but I'll tell everyone I've painted it, and I'm going to pay you some money for it. Although those contracts themselves are a little interesting under the Berne Convention. The other interesting thing the Berne Convention protects is the integrity of a piece of work. There was someone, for instance, who was buying paintings and cutting them up and collaging them onto their own paintings, and the Berne Convention prohibits that. Again, that's prohibited through the Copyright Act. It also prohibits people buying sculptures and just saying, we'll chop the top off them so they'll fit in the lobby of our building. And that happened a few times. Or it doesn't fit in upright, so we'll stick it on its side. So it's a piece of modern art, you know, you just, well, what's the difference? You can just turn it on its side and it fits in fine. And again, the Berne Convention, protection of moral rights protected that. Okay, so where do we go with second? Does that mean that you can continually just stack more rights when you sell something to someone and say, oh, by the way, I'm not really selling you this. What I'm doing is I'm licensing it to you, subject to certain usages. So the original attempts to do this was with secondhand books. And the American, and this is not a strong authority because it doesn't come up very often, because people aren't silly enough to litigate it very often. And the reason they don't want to litigate it, say in Australia, is they don't want precedent set. They don't want to be in a position where they will lose and actually have this doctrine reinforced. So because of that, people retain their rights to sell secondhand books. Now that came under a very interesting recent review, and the case, if I can find it, is the Kurtzing case. Kurtzing and John Wiley and Sons Inc. 2014, and that dealt with downstream. We call downstream rights. So it's rights of people who sell it further downstream. In that case, that involved a book publisher who sold books in Thailand at a vastly discounted rate. And the defendant in that case was an Thai-American citizen who imported the books from Thailand, resold them, and made it quite an astonishing amount of money doing that, which tells you how much markup there must have been realistically on the American copies of the books. Now, part of the distribution agreement was that these books were to be sold in Thailand and were not to be resold. And part of the contract of sale was that you can't resell these books. And the question was that legitimate? And the courts said that it wasn't. Now, a lot of the rights interest lobbyists talk about this as a grey market. It's not a black market because they're not actually stealing stuff, but it's a grey market. Now, I find that term to be problematic because it implies there's something wrong with what people are doing when they're reselling something that they've bought as a second-hand book and still making money on it. So I'm very dubious about people talk about the grey market in imported goods, because what they're really saying is, you know, in the globalised economy, producers of books or any kind of property already benefit from globalisation because they can have them made in China and they can pay workers a tiny amount of money to have them produced compared to what they would do in the West. fair is fair if consumers can also benefit from globalization and purchase products in the cheaper parts of the world. Now, the sellers will then fall back on this kind of argument around licensing agreements and licensing regions, and say, well, you know, they can't. The market in the developing world is so small that, you know, they can't charge the high rates they can in the West. Well, I think at the end of the day, you can't have your cake and eat it too here. You've either got to, you know, globalization is here. They're benefiting from it. The consumers need to be able to benefit from it as well. And certainly the tenor of what the High Court said in the Sony case, which we referred to earlier about the modding of the PlayStation chips, and DVD regions, I think, are an excellent example as well. And in the PlayStation case, Sony effectively said, but we have the right to set prices for different regions, and we have the right to effectively charge twice as much to Australian consumers as we do American consumers. And the judges actually asked, well, why do you think you have the right to do that? And they said, the corporate licensing projections, money, and the judges didn't find that very convincing. And they said, well, Australian consumers have the right to buy the same product from whatever they market they find the cheapest. And if you produce restrictions on your machines that stop them doing that, then they're entitled to modify those machines so that they can buy product from that other market. Which is pretty strong coming from the High Court, which was a pretty conservative High Court at that time. So interesting pro-Australian consumer, strong position taken there. Now, I think that's the same with regions. I think you could definitely say that people have the right, on the basis of that case, people have the right to modify the regional zoning on players. Because in the Sony case, the thing was you could also play pirated games, and the High Court said that doesn't matter. It doesn't matter because because you're locking down your markets to restricted areas. The consumers have the rights to do this, even though it allowed them to play pirated games. If it was only allowing them to play pirated games, it would be a different matter. So they were taking a very, very punitive attitude to what Sony was doing. So I suspect they would do the same thing with regions, and region coding and region modification as well. It's funny, I remember when DVD players first came out, and there was a place in Brunswick, I think, that started, you know, advertising that they would modify. Many DVD players had an internal setting that you could just flip. You could open it up and flip a switch, and it would enable it all region. Because the DVD player, the people producing them didn't want to buy into the region coding thing either. And at the time, there was a whole kind of, you know, is this illegal? Is this some kind of shady thing going on? People are modifying DVD players so you can buy DVDs from America. Again, at the time, half the price of what they're available here. And at the end of the day, these are basic consumer rights. Yeah, I think this is an interesting area from that consumer rights point of view. Okay, so the area that does where things start becoming murky, I think, and the reading for this week on video games mentions this in terms of copy protection and forms of digital rights management that stop people being able to resell. It's also relevant for technologies that you just can't resell from, like Kindle or the iPod, where the whole technology, the download technology, is designed so that you buy one, right, and you just physically can't. You don't have a thing that you can resell. And there was I actually haven't followed up on what happened with the whole secondhand iTunes song market thing. There was a big deal a few years ago. I'll check up what's happened on that for next time. but the changes to technology, and Brendan's just asked, are Apple's end user agreements completely legal? Completely legal or completely enforceable? Not often. And I've referred earlier to the human centipede episode of South Park, which is a classic in the area. Not for those with a weak stomach, but in that episode, the iTunes updated click and flick agreement had consumers agreeing to be experimented on with sort of horrible experiments and things as well. So yes, if you know South Park, you know what sort of territory you're getting into, particularly if you know the human centipede. But the point they were making was an interesting and I think quite a valid one, was that no one actually reads these agreements and they slip all sorts of stuff in there. I remember a few years ago, Chrome updated and they put in a term that said anything that you use Chrome for, the copyright is owned by Google. And they did this. They now say it's by mistake. And I think I agree that, I believe that they did that by mistake, but it created a huge stink straight away because it basically said that anything you work on, I'll say like a Google Doc, is in copyright. The copyright's owned by Google. And every few months, there's a new fight over Facebook and Facebook trying to claim copyright under their licensing agreements of everything that people post on Facebook as well. Anyway. So yeah, just because something's in a licensing agreement doesn't mean that it's necessarily legal, and quite often they try things on. In the reading this week, they were looking at the way they were trying to use the Digital Millennium Copyright Act anti-circumvention provisions to try and lock down the second-hand market for video games, which they've stopped trying to do because it was created enormous consumer backlash. Whether they would be legally able to do it is a very interesting question. The other frontier, which we looked at in the readings for this week, the additional readings, which is the Werner and Autodesk decision and the Oracle decision. Werner and Autodesk is an American one, which seems to step away from the first sale doctrine. And the equivalent decision, the Oracle decision, is a German decision, which seems to embrace it. Now, I'd recommend having a look at both these cases. I don't often tell you to read cases, and I certainly would suggest you have a look at the How to Read video I put up recently. In terms of when you read cases, you don't just sit down and read the whole thing. There's ways of skimming and looking through them and looking for key things for them. But it's really interesting to contrast both the way in which the genre of case law is different from America and Germany, but also the different approach they've taken on this issue. What this largely concerns is the attempt to try and change the software arrangement, the relationship between IP holder and consumer, from a sale relationship to a rental arrangement. And these both cases involve expensive professional level software, and software which often has a student version where people are buying student versions and then reselling them onto others, and that's a breach of the licensing agreement, as there are a whole lot of other things. I think the Autodesk one, it breaches it if you take the software out of the jurisdiction in which you bought it, which is quite an amazing sort of thing to put in a contract. You wouldn't think you bought some software, they said you can't take it out of the country you bought it in. Anyway, in both those cases are unclear at the end of the day. Neither of them are binding on us, but it is interesting that this is an evolving area, and this is an area where software producers are saying, well, if we can't control sales, maybe we don't have to sell software anymore. Maybe we just have to rent it out to people. In which case, we can have a whole lot more rights because first sale will not apply. Okay, I've got a question from Grant here. Isn't there judicial reluctance to find a meeting of the minds occurs in click-wrap contracts? Yeah, and click-wrap contracts are, I think, one of the best examples of the difference between black letter law and real law. Because when you learn black letter law, you just look at what the legal principles are and you say, if this goes before an appeal court, this is the decision the court will make. But you think, what are the chances of these actually appearing before an appeal court? You know, most people are not going to get involved in litigation, and most people are going to concede well before something goes before a superior court. So yeah, I think where it really comes down to it, if the High Court got a good look at click-wrap contracts, they would be very sceptical indeed. However, to the average everyday person, it's not a question of that. In fact, the average everyday person, they just click them, they never even read them. But if something did come up and they did fall foul of it, they probably would concede to pretty much anything rather than having to go to court. All right, so the point we're heading to, and I know you've heard a lot of me talk tonight, but I'll give you a chance to ask questions in a sec. But the point we're getting to, I guess, is this idea of the balance between the idea of legal freedom and the idea of licensing agreements being able to people being able to freely enter into whatever agreements they like, and the courts being able to back them up. And on the other hand, this paternalistic idea that you get out of consumer protection law, where the courts are saying, no, people are stupid, we have to be able to protect them from doing stupid things, and we have to protect them from predatory behaviour. And quite often that is the position that wins. It would be nice, I think, that everyone were educated gentlemen and gentle ladies who sat down before they, signed a new mobile phone contract and said, yes, I will read all 75 pages of 6-point print, and I will think about it. I will consult my attorney before signing this. I will read through all the pages of the latest update on the PlayStation Network before I press all the click yes, let me get into it. But at the end of the day, people don't do that. And the role of consumer protection law is to protect them. What happens when we take the next big step into cloud-based computing? What happens? I'm sure, hopefully you've all had a chance to use Google Docs. Extremely useful tool. But what's interesting about Google Docs is it's not Microsoft Word where you buy a disk, those old-fashioned things, and you install it on your computer. It's not even new Microsoft Word where you just download it onto your computer. All the important stuff that happens with Google Docs happens on a computer somewhere else, somewhere in the Google world, and they have computers everywhere because they're Skynet and they're taking over the world. But that's what cloud-based computing is about. It's about the local computer not only being a way into the real computers where the real processing power is occurring, where the real things are happening. And in those cases, I think it's much, much more convincing from a legal point of view. From a consumer point of view, it could be a disaster. But from a legal point of view, it's much more convincing to be able to say, you are only licensing people's access to that service. They're not buying a product. It's a different sort of relationship. It's a different sort of contract. So, for instance, and it's particularly true when something's a free product. I mean, people think, Facebook makes a lot of money out of its advertising. Obviously, it makes enough money for it to actually operate. However, people are not really in a consumer relationship with Facebook. They are, whatever crazy licensing restrictions Facebook puts on them, they probably should, in many cases, they're going to have to take it because they're not in a purchaser seller relationship. They don't have the protection of those consumer laws. The same with Google Docs. It'd be really terrible if Google took away Google Docs tomorrow and said, that's it, no more. All your files are gone. And too bad. If you haven't backed them up or saved them somewhere, too bad. It'd be a disaster for me, I know, because I'm terrible at backing things up. However, my relationship with Google, in relation to Google Docs, is not a consumer relationship. I haven't bought a product from them. Maybe have I bought a service from them? I'm not sure. I haven't paid any money for it. I'm using it for free. So anyway, leaving that, that's probably the a sort of a ramble through the material I wanted to sort of discuss tonight, albeit through the arbitration. I think this is, for me, an interesting example of how even sort of dry black letter doctrinal law can be really interesting when you start digging into it and start looking into it. And it becomes particularly interesting when you start looking at the globalized world and you look at the role of the courts in that global context. But it's copyright law. It may not be everyone's cup of tea in any case. So chance now to ask questions. Next week we're moving on to patents for 2 weeks as our focus area, and we're looking at the idea of biopiracy. It's all very exciting and globalisy and the West against the developing nations sort of issue, but it's a bit of dipping our feet into the world of public international law, which is, again, exciting and can be quite confronting. Okay, I know that's calling it turning a bit early tonight, but without a presentation, it's possibly all I have to say on the topic. Question?
Just before, you mentioned obviously which I've not sort of really thought about it in these terms before, and this might be why I'm struggling a little bit with some of the IP concepts. You mentioned the difference between the black letter law and the reality of people not wanting to litigate.
Yeah.
So there's probably, big corporations imposing their will on people who, if they're mums and dads, who probably represent millions of consumers, they're just going to back down immediately. They're not going to contest it or do anything about it.
Yeah.
Whereas it's probably a different situation. I'm sure the licensing regimes for the big end of town, for big business, they're going to be sort of, very focused on the black letter law and making sure that everything's squeaky clean, and they're probably going to stand up for their rights. Is that sort of fair of me to say that?
Yep, that's completely right. And it's in some ways it's why there isn't often, although the one of your peers posted a piece on the forums on the Dallas Buyers Club litigation, where they're really going hard against people who are downloading pirated versions of Dallas Buyers Club for whatever particular reason, and are getting warrants against ISPs and things to try and chase those consumers. But generally, most of the big stuff is around the big end of town, and those Autodesk, the Autodesk case is CAD. It's the architectural software, which sells for tens of thousands of dollars. So generally speaking, the fact that individuals are pirating it, they traditionally don't care that much about it. Although if someone's enabling it on a big scale, they care. But where the nitty gritty is on that is on architectural firms, and whether architectural firms are using properly licensed versions. Because if Joe Schmo down the street's using a version, it's like, well, they haven't paid for it, but it's not really harming their business at all, and it would cost them too much. But it is inconsistent. And one of the things we do, and I think one of the things, the black letter law approach is sort of like safety wheels, because when you're in first year, this stuff is, it's probably way too complicated when you've been out in the world for 20 years like I have, although the complexity of it is something I find intriguing. But when you're in first year, this kind of stuff kind of is way too much. So what we do in subjects like contracts and torts is we try and constrain it a little bit, and we try and talk about just what the courts have to say. And we don't worry too much about what the rest of the world does. But as we go on, you know, we open that up and we look at those topics in a more complex way. And IP law is definitely one of those things. So you've got to have two brains running at once. One is your black letter brain, where you go, if this goes to court, this is what the court would say. And your other brain is the, well, who's going to court? Who's not going to court? What's happening to people who aren't going to court? Are they settling? What's going on? And I think one of the articles I was reading on the Dallas Buyers Club situation referred to what they call porno trolling, which is what they reckon is a practice that the Dallas Buyers Club IP holders have been inspired by. And this is apparently a practice by which companies who are IP rights holders for pornography are very, very, very successful in litigating against or settling out of court with people who have illegally downloaded stuff, because people are not willing to, they're probably not willing to tell their families, probably, let alone to actually go to court and say, I didn't download this whatever pornography, and open up that whole kind of discussion and the proof, and out comes the ISP's records and the details, and then there comes the details of all the other things that have been downloaded legally or illegally that are on the hard drive. So pornography businesses have been very, very successful in protecting their rights and suing people who have been illegally downloading, and it's completely off the radar. No one really knows what's going on, except for the occasional person who stands up and says, I don't care what people think, I'm going to respond to it. The suggestion is that they can hit people with quite small demands of maybe $2,000 to $5,000, and they will settle straight away. They're going to say you're going to pay $20,000, and people might have to bite the bullet and go, yeah, I'm going to go to court. I'm going to have to defend this because I don't have $20,000. But $2,000 or $5,000, $2,000, you could actually be quite effective in setting letters of demand where people are not going to tell anyone they've had that letter of demand. They're going to pay it out quickly, get an extension on the credit card or whatever you need to do it to get through it. So that's I guess it's a roundabout discussion of, but I think that the Dallas Buyers Club situation is that a change in the field? Are we going to see more litigation? People have gotten very comfortable using BitTorrent software. They've gotten very used to it, to the point where a lot of young people don't even seem to realise that it's illegal what they're doing. Or they just go, oh yeah, illegal, no one's going to do anything about it. But if they start putting resources into it, who knows?
So out of interest then, because this sort of ties back into that remix, I can't remember what it was called, the remix video where Warner Music and the record companies were threatening mums and dads for downloading music and settling out of court and all that sort of stuff. How did they identify all those people in the first place? I mean, I know that the privacy sort of situation in America, I believe, is a bit different. The way that the internet traffic is monitored and emails are monitored and a whole lot of stuff. I can remember seeing articles on that in constitutional law. But I'm just sort of wondering, how do they enforce that? How do they identify all these people? It's one thing to see a website that is hosting a file, and you can see, and you can, potentially identify, who owns the domain and take some action there. But to actually identify the 1,000 people in the United States who downloaded that music file, how did the record companies do that?
Warrants. You convince a judge. You convince a judge that there's sufficient grounds to get a warrant, and you go into an ISP and you get all the relevant data. And this is what the big contentious issue around the Australian government's data retention plan is all about, because it would make it easier to do this. And they're basically working towards a position, and there's not been a lot of outcry about it. And basically, I think a lot of people are going, oh yeah, but it won't stop me downloading Game of Thrones, will it? Yes, it will. If you can hit a big enough ISP with a powerful enough warrant, you can get all the details. This is what they did with the Dallas Buyers Club. of who downloaded it, what IP address it went to, if they shared it, what IP address it went to then. If they're all going to an IP address through another big ISP, you then get another warrant against that ISP. You get all their data, you get all the places it's shared to. So all the people from the and they'll go after Telstra or Optus customers. It may well happen. The data retention laws want to move towards a position, or they're a movement towards a position where ISPs should be sharing this data with law enforcement. And in the early days of the internet, British ISPs were very helpful with law enforcement and sharing stuff. They seem to have pulled back and are a bit more concerned about their customers' rights now. But it's a very contentious field, and it's interesting that there's not such a big public deal. That it seems to be getting very, very little public attention, and particularly from the very people who are the ones who believe they're entitled to download and want to have whatever they like, which is tricky because so much stuff takes so long to come to Australia. But that of itself is not, I suppose you could argue some kind of time shifting that you're doing there, but it'd be very difficult if you had your Optus's records pulled that said you had downloaded all these episodes of Game of Thrones, to turn around and say, yeah, but I was intending to buy the DVDs later or something. I don't know what sort of argument you'd make, but I think it's largely just ignorance. I think it's just largely, and particularly people who've grown up with torrenting just see it as part of what they do. It's not even seen as terribly kind of like an ethically grey area. It's just something people believe they're entitled to do. And number one, if the laws change, it'll happen very quickly. But even under the current laws, if property holders have enough resources and time on their hands to start getting the warrants together, we could see things changing very rapidly. At the moment, it's more the case that their response is kind of sporadic. They don't have the resources to do very much, so they'll do something like the Dallas Buyers thing to try and make a big impact, and then you won't hear about it for a while. It's will customers be able to sue the provider? Not if you're doing something illegal. Because if all the provider is doing is granting a legal warrant and granting law enforcement access to your records under a legal warrant, there's nothing you can do about it. If they volunteer it, that may be a breach of confidentiality, I would suspect. But again, you're in that field where are people going to want to have those records exposed? So hypothetically, if someone says, okay, we've had a warrant for your ISP, we have all your download records of everything you've downloaded for the last year, including these movies, but if this goes to court, all your other download records will also go in there and it'll be a matter of public record. There could be things in many people's accounts that would mean that they'll go, I'll just pay. Whatever it is, I'll pay. I don't care about the courts knowing I've been downloading from this site, but I'm worried that my partner, my children, my parents will find out what's been going on there. So it's, I guess...
Then does that expose people's political beliefs and religious ideas in terms of, the sites they visit and what they download? Because if they go to an ISP and essentially they're just getting lock, stock and barrel, this is, what these people have downloaded because they're looking for something specific, but in the process they get access to all of that, then there's going to be isn't there going to be, I know we don't technically have sort of privacy per se, but there is, in terms of freedom of speech and sort of political views and sort of that type of thing, I would have thought there would be something there to prevent that.
On those,
and something else.
Yeah.
Sorry, and just...
You go.
Sorry, I was just going to say one other thing, because you could respond to this at the same time, is that when you talk about the black letter law reality and what actually happens in the market, if these type of laws were introduced, wouldn't that just encourage people to download via a third-party proxy located in China or Russia or somewhere else, so that, sure, you could see what information is being downloaded here, but you're not seeing where it came from because it's coming from, through a third-party source. So surely there'll be other ways around that. So it seems, I just wonder whether that makes it a moot point.
Yeah, I mean, I don't think for everyone, but I think people who are already worried about this are starting to use much higher security and proxies and everything else to protect their data. So those aren't, and often they're the people who probably have the most things to hide in terms of criminality. I'm not saying that people who use proxies are criminals, but people who are criminals are definitely already using proxies. The people who are probably going to be caught by this are the mums and dads or the kids in suburbia who don't know how to do this stuff and who just think that they're protected. But yeah, you're quite right. If it starts becoming more of an issue, people will start to learn how to encrypt better, and it'll raise the stakes. And probably, I mean, I use the word realistic, but I think maybe the better term to talk about would be regulation, black letter law versus regulation. And that's a whole fascinating world. It's like, there's what the law is, and this is how the law works in practice. And particularly in the area of criminal law, you can look at the difference between criminal law and criminology. Criminal law is about what happens in the courtroom. Criminology is about how the laws actually operate and who's caught, who's not caught, who's prosecuted, who's not prosecuted, what's the effect of the laws on people long term. So there isn't like a criminology for every other area of law, but just think about what the equivalent from criminal law to criminology would be for other areas. Like for contract law, there would be contractology or something, but that's regulation. And when we talk about regulatory theory, that's the world we're in. And it's disorienting, but it's also really, really necessary to try and understand, why do people obey some laws but not others? Is there a deterrent effect? Isn't there a deterrent effect? How do you get people to internalise values? Why aren't people internalising values? Why aren't people seeing illegal downloading as something why are they seeing that as a victimless crime or a victimless of whatever it is? It's technically a crime, but it's on the grey area. Anyway, did that answer both your questions? I can't remember what the first one was.
Yeah, all good, thank you.
So, it's a good thing this isn't a subject that has an exam in it, because the idea of being able to sum all this up in sort of 500 words or less is kind of crazy. But start having a think seriously about your, because we're hitting the halfway mark. You need to start getting a bit of a move on your research assignment and on those the DIGO communities. So start thinking about what topic you might want to do. I'll do a video over the next week which is about how to define a thesis, which will hopefully help you through the stages of going from a big, broad, open topic like law reform to something which you can actually handle in the word count and that can actually develop an argument around. So we're going to do a bit more work around that. All right, so any other questions? Otherwise, we might call it quits for this evening, and I will see you in the next session after the break. Okay. See you later.